The petition for appointment of guardian, legally incapacitated individual. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover SCAO form, State Court Administrative Office Form PC, Probate Court 625. This is the form that has just recently been amended in July of 2024 that's required for the filing of an adult petition for guardianship. The primary change in this form from prior forms is that this form now accommodates the request for a standby guardian. Michigan amended the statute to allow you to nominate and identify a standby guardian instead of just the primary guardian. Let's walk our way through the form to understand how to fill this out for filing with the probate court. Starting in the top left corner in blue, you'll see you identify the county. This is the county of residence of the individual you're seeking protection over. It identifies in the top right corner the case number and judge. This is generally going to be left blank because at the time you're completing this document, there will not have been a case number or judge assigned. In the bottom, you'll see in the purple rectangle the identification of the form number as well as the statutes and court rules that control this particular form. As we work our way through it, you'll see the court address and phone number, and then in the matter of. That is the name of the person upon which you're seeking the appointment of guardian over. In addition, you'll see in the top right corner, there's a spot for the last four digits of the Social Security number of that individual. It references using a form MC97. This again is a SCAO form that you have to use for this personal protected information so that it is not public information, the information about the dates of birth or Social Security numbers of the individual. So you have to attach to this form the MC97 form to identify the last four digits of the Social Security number. The petitioner's name is the name of the person who is completing this form, who's seeking the appointment of a guardian over the individual. It could be anybody interested in the well-being of that individual. And if there's an attorney, the attorney's information is identified to the right. In addition, there's a date of birth section, again, that is not on this form. You use the MC97 form as well as the driver's license number of that individual if there's a driver's license. The race and sex is also identified there, and then the address of where that person is currently found. Now, they may be at a residence, they could be in a facility, they could be on the streets, but you have to identify where they're located for purposes of the petition. As we work our way through the document, you'll see on paragraph 1, it says the name of the person. This is the person who is filing the petition, and you identify how you're interested in this matter. Maybe you're the spouse, the child, maybe you're the social worker, the neighbor. How are you interested in the petition that is being filed in relation to the person being sought guardianship over? The next section under paragraph 2 is an identification if there are any other matters involving that same person that are under the jurisdiction of the family division of the circuit court. So maybe there's a custody issue going on or some other matter or maybe a divorce proceeding. This allows the court to identify and consolidate matters as well as identify and ensure that any prior matters are assigned to the same judge. As we work our way, continue down to paragraph 3, it indicates the identification of the residency of that individual. Residency can often be quite easy to determine, and sometimes it's complicated because people often move over periods of time, or maybe they're on the streets. You identify the home address and telephone number, and if they're a citizen of a foreign country, that would be that section with the little click box. Again, further down, this is an identification if there's any estate planning documents currently in place, a patient advocacy, a power of attorney. If that individual who you're seeking appointment of guardian over already has a patient advocate or power of attorney identified in a document that you're aware of, you should click that box, as well as whether there's a conservatorship in place, and then identify the name of the patient advocate or the conservator or the attorney in fact as set forth in those estate planning documents. Again, under number 5, more information about that patient advocacy. Remember, patient advocacy addresses things like care and well-being and health decisions. You can identify the basis for the information about that patient advocacy designation under paragraph 5. Let's work our way now onto page 2 of this 3-page pleading. Page 2 identifies under paragraph 6 the basis. These are the reasons that they qualify as a person who is in need of guardian. Under paragraph 6, you have to identify if it's mental illness, mental deficiency, physical illness or disability, chronic intoxication, chronic drug use, or some other reason. These are the statutory bases for the establishment of a guardianship in Michigan. And paragraph 7 then asks for specific facts relating to recent conditions or conduct that makes you believe that that person is in need of a guardian. So for example, you'd identify a narrative. Now there's 3 lines there. You can use those 3 lines, or of course you can attach a supplement to that to fully flesh out the factual basis for the need for guardianship. But although you're stating it on the pleading, at the court hearing, generally you're going to orally advocate for the appointment of a guardian and flesh out those facts to show that by clear and convincing evidence, there's a need for the appointment of a guardian. Under paragraph 8, it identifies the care and custody as it relates to that individual. So the person who has the care and custody of the individual denied another person access. So this is a provision that identifies if somebody is in control of that individual, there's been a denial of access to the person that is seeking the right to visit, meet with, provide health and care, and that contact with that person is in their best interest. So the idea being that if you're denied a right to visit, you have a right to seek under paragraph 8. And a specific facts about limited guardianship to supervise access with the other person, that would be the provision under paragraph 8b. Paragraph 9 is who has current care and custody. This would, for example, be used with a facility. Paragraph 10 is a statement about Veterans Administration benefits. It's important that that information be provided. There is statutory and court rules that apply to giving notice to the Veterans Association for anybody being sought guardianship over. Paragraph 11 is quite important because you're identifying how the person, their family tree, who's related to them. Do they have a spouse? Do they have children? What are the level of relationships? And then below that is a description of the relationships and their address, phone number, contact information. This gives the right to those people to notice of the filing of the guardianship. You can't just pick and choose people. You have to fully disclose under the court rule and statutes those individuals who have a legal right to the information. Now, sometimes you don't know the information and you may identify whereabouts unknown, and there's a provision for how you identify when people are not known who the family is, but it's critical that you comply with this provision and appropriately identify the family members who are entitled to notice and receipt of the information regarding the petition. Just because a family member has just disappeared and is no longer involved doesn't mean they've given up their rights to notice. Let's work our way into page 3 of this document here. And page 3, it identifies if any of the people that were identified above are legally incapacitated. Are they also under guardianship? Are they a developmentally disabled person? So that the reason for this is that if those people are also under legal disability, there's certain rights afforded to those people as it relates to notice. Paragraph 13 is the request. What are you asking of the court? You're asking the court to determine that the individual is a person who is an incapacitated individual under the statute. You're asking the court to appoint, and then you're going to identify the name of who you're designated to be appointed. And how do they have priority? There's a statutory priority for certain people that you can identify. Maybe they're the spouse or the children, or maybe they're the person designated in the patient advocacy document that in the event of a need for guardianship, you have appointed somebody. You identify whether you're seeking full guardianship or limited guardianship with certain powers, and you can also designate the person as a standby guardian. So you could have primary guardian who may be appointed full guardian, and in the event that that person dies, becomes incapacitated, or resigns, you have a standby guardian available. This is really a great addition to the Michigan statute because it allows for that person who is vulnerable to not have a gap or delay in the event that somebody dies or resigns or becomes incapacitated. There could be a long period of time without a successor guardian coming into play. So the standby guardian provision helps solve that problem for the vulnerable community. As we work our way through paragraph 14, it says no other person appears to have authority under the circumstances, and you're asking for a temporary guardian. This is like there's some emergency going on, there's some exigent circumstance occurring, maybe there's a surgery, there's a placement decision that has to occur immediately, and you're asking the court for that basis. It's a statutory basis for using a temporary guardianship. Look at that statute for purposes of identifying whether it fits your specific criteria. And then there's a declaration that the information contained in this petition is true to the best of your information, knowledge, and belief. The petitioner signs, dates it, as well as if there's an attorney, there's a spot for the attorney to sign and date. Under paragraph 15, the person who you're seeking guardianship over can also identify whether they agree and consent to the nomination as set forth in this petition. If the person you're seeking guardianship over does not agree or is unable to agree, then that place would just simply be left blank. But if they are agreeing and consenting to the guardianship petition and the nomination set forth in there, you'd identify the information there, as well as for the standby guardian, and then that person would sign it. This document with that MC-97 form gets filed with the probate court in the county in which that person resides, and then ultimately a hearing is scheduled. At the Probate Pro, we are passionate about everything probate. If you've got a question about this petition for appointment of guardian or any probate or trust-related issue, visit us at theprobatepro.com or call 833-PROBATE.